Good evening, everyone. Good morning. A good day from wherever you're joining us. I'm Hitesh Hathi. I'm the incoming executive director of the Mittal Institute, speaking to you here from Cambridge at Harvard University. Very delighted to be able to address this gathering, to have all of you join us. I'm just going to say a few words about the Mittal Institute and about our events today. And I'm going to then let Professor Diana Eck take over and start the events. I won't take too much of your time. I want to say it's a particularly moving thing for me to be here with you today. One, because I'm a student of Professor Diana X, who's taught me so much over so many years in so many ways. So I'm delighted to be here with her. I'm also, I know that the topic we're about to discuss is a very difficult topic with a lot of emotions. A lot is at stake for the future of India. And the fact that we're discussing it is really a very moving thing for me. As Amartya Sen, who was present at the foundation of the Mittal Institute in 2003, pointed out, we are a civilization that is argumentative by nature. From the earliest records, if you look in the Upanishads, it's arguments. Even Arjuna and Krishna in the Bhagavad Gita is argument. The Buddhist tradition is argument. The Emperor Ashoka is argument. I think of Adi Shankara, who debated his way from Kanyakumari all the way to Kashmir. That is the nature of our civilization. Even the Mughal Emperor Akbar in his Ibadat Khana at Fatehpur Sikri delighted in the arguments of the scholars of the different faiths he had gathered there. So that is kind of the essence of our civilization, to be argumentative. And here we are to debate and talk about what is important at stake, what makes us who we are. The Mittal Institute is privileged to be a part of this discussion. We are an institute that was founded to advance the understanding of South Asia at Harvard, to enrich a mutual exchange through exchanges of scholarship, students. We facilitate scholars coming here from across the region. We also fund scholarship there. We have students coming back and forth in both directions from all over the region and to all over the region. We also undertake very large multidisciplinary projects. At the moment, we are in the middle of the Lancet Citizens Commission project, which is an ambitious look at healthcare in India in particular, but South Asia in general, all led by scholars in India. Professor Eck led us in perhaps the most ambitious project we've ever done, a study of the Kumbh Mela, where we involved scholars of religion, theology, public health, really architecture and town planning, almost every field, to look at how a festival like that gets produced, happens, what it means, how it's relevant to this day. We're also in the final stages of our large study of the partition. The book will come out at the end of this summer. So that's a little bit about the Mittal Institute. And I want to say, Professor Diana Eck, I just want to give a few words of introduction to her. Professor Diana Eck has been a teacher, advisor, mentor to a couple of generations of Harvard students. I was her teaching fellow for her large general education course. She has literally put India on the map for Harvard students in multiple senses. She is the one who reminded and taught us of how India is conceived of as a geography, psychological, sacred, religious geography. She has enriched the understanding of particular places, of pilgrimage routes, of sacred traditions. She's a scholar who studies both India and the US. She actually has done perhaps a groundbreaking project called the Pluralism Project, which mapped the religious diversity of the United States and produced a pretty major work called On Common Ground, which looked at world religions in America. Her books, I will not mention all of them, but the two that are about 4 feet from me as I speak are Darshan, which is Seeing the Divine in India, and Benares, A City of Light, which is a study of Benares over the years. Professor Eck, I'll let you take it away. Welcome to all of you. And I will be going off camera just so that the attention is on the speakers.
Thank you very much, Hitesh. It is a great pleasure to be here, and I owe thanks both to the Institute and to Hitesh Hati and to Namita Varma for putting this program together and for, in a very real way, introducing me to the three speakers who are going to be with us on this panel today. And I want to thank all of you for being here as well. So we're going to talk about the hijab ban and the future of religious pluralism in India. And when this was announced, I had a friend, an Indian friend, who said, oh, hijab ban, really? I mean, it's just 6 young pre-university students in a college in Karnataka who have instigated this litigation, and also who have been barred from attending classes wearing hijab. But this is not a hijab ban in India, generally, not at all. And so are we making too much of this? How is it that this issue has elicited not only national but international attention, so one can read about it in The Guardian or in the Times of London or in the New York Times? Is it just one more example of a widespread phenomenon? Others have claimed that that is the case, that targeting the Muslim citizenry of India is an episodic and persistent issue of discrimination and harassment. And why has this lit such a fire? Is this a rights issue? Does it have to do with the freedom to profess and practice and propagate religion as guaranteed by the Constitution? Is it a women's issue, a women's rights issue, a right to education issue? How is this issue in Karnataka related to the second half of our topic today, which is the whole question of the future of pluralism in India? And it's a good thing we have the panelists that we have to help us think about that today. We have Zakia Soman, who is a founding member of the Bharatiya Muslim Mahila Andolan, a mass organization of Muslim women in India, also the founder of the Center for Peace Studies, hosted by Action Aid Association. She's on the core of the South Asian Alliance for Poverty Eradication. She has argued issues before the Bombay High Court on women's entry into the Haji Ali Dargah in Mumbai, and was a petitioner in the Triple Talaq case. So she has argued extensively on behalf of Muslim women and Muslim citizens more widely, and Indian citizens more widely. And her articles on the tolerance and harmony of religious communities in India have also been seen as part of her essential work. Then we have Faizan Mustafa, who is a senior constitutional law professor, vice chancellor of the Nalsar University of Law in Hyderabad, also a founding vice chancellor of the National Law University in Orissa. He is known for institution building and democratic leadership, and has been awarded the Best Teacher of Law award, which is, I'm sure, fairly coveted among people who teach law. And we are delighted to have Faizan Mustafa with us again today. And then we have Sai Deepak, who is an engineer turned litigator who argues before the Supreme Court of India and the Delhi High Court. He has over a decade's practice now as litigator in a whole range of areas, but among those that have attracted nationwide attention He argued the Sabarimala entry issue on behalf of women entering the Sabarimala temple, and has also recently argued a case on Padmanabhaswamy in Tiruvannamalai. So we have people who are expert in a variety of areas and give us a variety of voices in investigating and discussing this issue today. So we'll proceed sort of like this. Each of our panelists will have about 10 minutes to begin to expose what it is they think about this issue. And then we will have an opportunity for them to ask questions of one another. And for those of you who are registered for this, to submit questions, which will be vetted by Namita Varma. And we'll begin today with Zakia Soman, with the whole question of whether hijab is mandatory for women in Islam. Is this a patriarchal construct of Islam that is not really a necessary part of Islam? And how does that relate to women's education, women's rights, the right to education, and the right to practice their religious faith? So, Zakia, why don't you start us off on this?
Hi again. Thanks, Diana. Before coming to your specific comment, I would like to say that this recent controversy over the hijab in Udupi in Karnataka is totally uncalled for, because we are talking here about an education institution. And what is the hallmark of education institution? Where if we can, is to resolve differences through mutual understanding, through mutual dialogue, through mutual kind of a communication. So I feel that it should have been resolved at the level of the PUC college, between the faculty and the management and the girls' parents. Having said that, we failed to do that. That only suggests the kind of religiously polarized atmosphere that we live in our country today. So it became into a full-fledged Hindu versus Muslim kind of a controversy, which is really, really unfortunate, and which is something we all need to reflect on. I would also say that the kind of secularism that we have a lived kind of secularism in India, and the secularism which has been talked about and upheld by the Indian Constitution is somewhat different from the secularism that we see in the democracies of the West. In the sense, the same Constitution also gives us the full right to religious freedom. And we have markers of religious identities such as, so many, in all religions, and they are, part of our, not just our personal lives, but they are also part of our public lives. So singling out these teenage girls in hijab for a ban, according to me, is outright discriminatory. And it is a case of double standards, and it is a case of politicizing the religion and religiosity of Indian citizens. That is my first point. Having said that, I would also say that there is no doubt in my mind that hijab is nowhere an essential practice of Islam, and it is certainly not mandatory for Muslim women. There are any number of progressive scholars, Islamic scholars, including feminist Islamic scholars, who have done a great amount of work to prove that this is a patriarchal imposition, and it has not been ordained by Islam upon the Muslim women. And my favorite scholar is, and I'm sure she's the favorite scholar of a lot of law students there at Harvard also. She is Fatima Marnisi. And she has done in-depth research on the subject of women and veil in Islam. And she has told us how the usage has been, in the sense of a barrier or a division or a kind of a curtain or a kind of a distance, usually between males and in male social contexts. The number of times the word has been used in the text, it hardly applies to women in a couple of situations. Rest of all the situations, the word has been used with reference to men. But later day, it was used, it speaks for the kind of patriarchal society, the male-dominated society that, we were. Immediately after the Prophet, it was, the meaning of the word was totally distorted to confine women behind a veil and to confine women in the four walls of the home, and truly to make women second-class citizens. Whereas Allah nowhere differentiates between man and woman or girl and boy. And Allah calls for equal rewards and equal punishment for any good that is being done by a man or a woman. So, we know that it's very well known now that over the centuries, it has been converted into a kind of a veil, or so in some contexts it is hijab. And in India in particular, and in South Asia in particular, the arrival of hijab has been relatively very, very recent. In the sense, our mothers and our grandmothers did not wear hijab. Our mothers wore either a sari or a salwar kameez, depending on which part of India, one was born in and one was raised in. So it's only the Arabian influence in the form of a hijab or a full covering veil, which has come to the Indian subcontinent in the last say 25 to 30 years, which has now become very, very fashionable. We have girls who wear hijab, whose mothers and whose grandmothers were never seen in hijab. But having said that, I also would say that I am somebody, as a feminist, I respect the choice of the girl. And I only hope and pray and wait for her to sort of educate herself, to enlighten herself, and to empower herself to someday realize that it's not, a decree by Allah. It is only a patriarchal imposition. And my hope is that as the girls educate themselves and they go further in their lives, they will all discover that. But this ban, the recent ban on girls in hijab in the classroom, has precisely intervened in that process of education and empowerment of girls who go to the schools and the college. So as a result, there has been a number of girls who have dropped out. They have not been allowed to write their examinations because they have been denied their entry into the classrooms and into the examination halls. So that's really a travesty of fate or a travesty of justice, that on the one hand, the girl who is adhering to an attire which she believes or which she is given to believe by the society and by the surroundings and by her parents and by the community, that if you are a Muslim girl, it is essential that you wear this piece of clothing. So she is being made to choose between right to religious freedom as she understands it and right to education. So I think in the world's largest democracy, where we have such a long tradition of harmony and peaceful mutual coexistence, for centuries and centuries. And I'm not saying it has always been flawless and peaceful. There have been aberrations, there has been communalism, there have been communal riots, but despite of those communal riots and those aberrations, we have stuck together, we have survived together as a multicultural, multi-faith, plural society, where all of us have been, equally to practice our own religion beliefs and traditions, which now seems to have come under a lot of pressure and lot of scrutiny, thanks to the politics of religious bigotry which we are seeing around. So, one's religion, one's spirituality is one thing, but to have a competitive religiosity or to weaponize one's religion to sort of thwart other people's right to religious freedom is something totally else. So we need to differentiate between religion and political religions. And so the girls, these 6 girls and a few more who have all dropped out of their pre-university college, who have all not sat down to because of this politically charged atmosphere. Over to you, Diana.
Yes, may I ask you one question, Zakia, because it's been unclear to me. Exactly what were the girls trying to wear? Was it something that was fuller body cover, or was it also simply a headscarf?
Yeah, so the present controversy, when we say hijab, it is referring to the headscarf.
Just the headscarf?
Yes, the headscarf.
So they just wanted to put a headscarf on when they went into class?
Yes.
Because, the depictions of them are, a full body covering, really, not the, yeah. So it's just the headscarf. Go ahead. If we get Zakia's audio back in just a moment, we'll let her finish that thought. Yes.
Yes. So they could have, they could have specified, the education institution could have specified the color of the headscarf to go with the uniform, something like that, and not allowed all the different, colors and designs over there. And it could have been resolved. And something like, once they enter the classroom, then they have to, adhere to certain laws, certain policies. They need to remove the head, something like that. Some conversation, some dialogue should have taken place, and we shouldn't have allowed it to blow into this kind of a controversy.
Thank you very much. And I think at this point we'll turn to Faizan Mustafa and ask about the decision that was rendered by the courts in Karnataka. What do you think of that decision? A judgment that this hijab is not an essential part of Islam, which in one way is what Zakia has just been saying as well, from a different standpoint. What kind of restrictions does government have on the freedom to profess and practice and propagate religion?
Thank you so much, Professor Diana. And I entirely agree with Zakia. We had our differences on several issues, but whatever she said, I endorse. But let me just straight away say that I have been opposing the whole doctrine of essentiality. Whether X is an essential feature of Y religion or not should not be the concern of the courts. Courts are not supposed to reform religion. In fact, I have been writing that the court should not become clergy, because this is not their job. They are not trained in religions. They are trained in common law. And therefore, if at all they need to restrict somebody's freedom of religion, they have enough scope within the law. So on the freedom of religion, as you know, if you read Article 25, it starts with subject to public order, health, morality, and other provisions of this part, which means part 3 of the Constitution. So framers of Indian Constitution, while guaranteeing freedom of religion, were of the view, in a way, that religious freedom should be subordinated to all other freedoms. So compared to right to equality or compared to right to non-discrimination, they consider that religious freedom is less important. and that's why it has been subordinated and made subservient to other fundamental rights. Now, having said that, coming to the whole question of Karnataka High Court judgment and why it is problematic for me is one, as you were discussing with Sai, who is a good friend and has been to Nalsar, that Supreme Court itself at this point of time is in doubt about the correctness of the whole essentiality doctrine which the court had propounded. The court has already framed 7 questions. We were going to have a hearing during Chief Justice Bobde's tenure. Then the COVID came in and Justice Bobde retired. And therefore, ideally, in my opinion, what was before the court in Karnataka High Court was not like one individual asserting her right and a community right, and the court called upon to pick up whether it goes with the individual's right or the group rights. That was not a question. That was a question in the section 377 homosexuality case, but not here. Here the question was that there was a rule made and there were people who were affected by that rule, and to test the legitimacy and the legality of the rule, you are not supposed to get into individual versus group rights debate. Rather, you have to look at the whole question of reasonableness of the restriction, whether the restriction is arbitrary or fanciful, or you have to see whether it is proportionate, whether there can be a less intrusive restriction. And that's why Zakia was rightly mentioning that there was, in my opinion, scope to make a reasonable accommodation to the claim of 6 young girls who wanted to have a headscarf by saying that just like what we do about the central schools, which are under the government of India, which permit that if your headscarf or uniform, you would be permitted to do that. The High Court did not permit even that. I think what High Court should have probably done, it should have allowed this reasonable accommodation and said we would like to wait for the Supreme Court decision on the whole question of the essentiality. Now, what are my problems with this whole essentiality debate? If you look at the Supreme Court judgments, first, Supreme Court has been looking at scriptures as if they are enacted laws by a legislature. Now, this is an absolutely wrong understanding of scriptures. And for a person like Professor Diana, who is familiar with this scriptures and religious text and statutory laws, both are entirely different. They are not to be taken like that. I had this problem with Supreme Court's ruling of even about Quran. I have been writing that Quran is not a book of law. It is a book of principles. It is a book of stories. You cannot say that if something is not there in Quran, it is not part of Islam. Similarly, you cannot say if something is not penalized in Quran, then it is not an essential thing. Because the whole problem with the Karnataka judgment is that the Karnataka judgment is saying, relying on Sabrimala's judgment, we would see if this practice is not permitted, whether the religion will cease to be a religion, whether its glory will be lost, whether it was there when the religion was founded, whether these people were practicing it before or they now started to practice. In freedom of religion, you can't be saying, Professor Diana, that, well, Professor Mustafa, you were not praying yesterday. Why did you start praying today? I may start praying today. And you can't be telling me that you did not do it so far, so we will not concede this kind of thing. You see, in the United States, we follow what is said to be an assertion test. If I assert that I believe in X practice, that practice is to be recognized. Rather than courts going into the scriptures, applying their own, methods. There are cases where the court said, well, this was a case from Kerala, where some policemen wanted to sport a beard, and the court said, well, Professor Mustafa doesn't have a beard, and that person doesn't have a beard, and therefore it is not an essential feature. Similarly saying, well, it is not there in Quran, therefore it is not an essential feature. Or to say that this is superstitious. From Ajmer, there have been cases which were not, considered part of the Sufi tradition by saying that they are not, they are superstitious. Many things in religion, are based on superstitions. Similarly, I say that everything which may be in Quran or within any scripture is still as a modern, progressive, liberal democracy, we may not allow. So I am not making a case that if X thing is in a scripture, allow it, and if it is not there in the scripture, don't allow it. We leave it to the clergy. We don't try to reform our religions. As a legal system, we would say what we will permit. So there may be things which may be in Quran and which may be essential. Let us take, for example, though there is a debate whether slavery is there or not there, but there is slavery as an institution which was not really abolished by Islam, so to say, explicitly, if you want me to concede that. But can we permit slavery today? Or what Zakia has been arguing, that triple divorce is not there in Quran, assuming it is there in Quran. Should we allow it? My case is we should still not allow it. My other problem with this whole Karnataka High Court judgment is about the privileging of one religious practice over another. This is, I think, the central problem of the whole essentiality doctrine. There it is the court which says X practice is more central to your religion than Y practice. I think religion as a whole is to be understood. We can't be privileging one practice over another. Similarly, we can't be freezing practices in religion. You have Anand Margi's case in India. They wanted to do the dance on streets, and the Supreme Court said, well, this is not there in your original book, first edition, Karya, and it came after 3 years. If we apply this text, the whole of the Christianity, will be in problem because it come, after Jesus. Or whole of Islam would also be in problem because the entire jurisprudence was developed many centuries after Prophet. So just my last point is that the distinction, as a student of law, the distinction which the Karnataka High Court makes between substantive rights and derivative rights, and they say that these petitioners have not come up with an argument about a substantive right, like right to privacy or like right to freedom of speech and expression. And then they say, well, in the public places, there can be even restrictions of the substantive right. I think we go by the Vienna Declaration of Human Rights and believe that all rights are universal, they are indivisible, and they are inalienable, and they are interconnected. I concede that the petitioners, rather than making an argument that it is their religious duty or it is mandated by Islam, that's why they are doing it, because this is a compulsion argument. They were saying, well, our religion forces us to have it. They should not have argued this. They should have rather argued it, it is our choice. Whether this choice is right or wrong, as Zakia rightly said, is for them to decide. Whether this choice is Islamic or not Islamic, there can be a scholarly debate about it. But the argument should have been made in terms of their self-autonomy, in terms of their personal choice, in terms of their conscience. I believe that the meaning of freedom of conscience, which the court has given, is also highly restrictive. And then how the court brings in the whole discourse about fundamental duties. Fundamental duties are not there in most liberal constitutions in the world. We brought in during emergency. And even Mrs. Gandhi, who, so to say, was an authoritarian leader, could not put fundamental duties in part 3 and make rights and duties correlative. So you cannot say that you cannot have your fundamental right unless you perform your duty. I think both stand on a different plane, though increasingly our courts are saying that both should ideally be given effect too. But whenever it comes to be the question of a right, it should be looked at as a question of civil liberties. I feel that personally in this case, ideally the court should have made some interim order and left the larger issue for the Supreme Court judgment, which is reviewing Sabrimala. Court has framed 7 questions, and that would have been a better thing. But as to the future of religious pluralism in India. Just last sentence, I would say, our constitution guarantees substantive freedoms to the religious minorities. It guarantees them a kind of an absolute right in Article 29. Anyone who has a distinctive language, script, and culture will have a right to conserve the same. Minorities have been given their right to set up educational institutions of their choice. There is an individual's right to freedom of religion under Article 25, and then a right to the group in Article 26. There is no religious tax in India, and Muslims are all over. They are not being marginalized. Might take a slightly different, Professor Diana. The entire discourse is about them. So, in a way, whatever debate we are having in every election, they are the talking point. It is Muslims, every politics which is being done is about them. And in a way, that is good.
Thank you very much. What a provocative and interesting presentation. And I think we probably should go right on to Sai Deepak and get your perspective on this. Sai Deepak has been a litigator in some of these high-profile cases. So, Sai Deepak, what is the role of the state then in imposing restrictions in government and government-aided institutions? What are the larger implications of this Karnataka decision?
Thank you for the questions, Professor Eck. And before I answer your questions, allow me the indulgence of a few preparatory remarks. Firstly, I think in terms of the framing of the issue itself, perhaps this entire controversy could have been resolved if the issue was limited to a very specific context and in the backdrop of the specific rule that was in question. And that effectively ties to the manner in which perhaps today's debate, or let's call it a discussion, not a debate, has been formulated, because I genuinely don't think of this as a hijab ban, so to speak, because the moment you call it a hijab ban, it invokes comparisons with certain, let's say, proscriptions which are prevalent in certain parts of Europe, which is not the case here. The limited issue was with respect to the application of a rule which was uniformly applicable across the board to students of all religions and not to a particular community itself. That needs to be clarified before this stereotype is reinforced that this was a hijab ban in the first place. Because there is no prescription, no law whatsoever that prohibits any member of any community from sporting their visible religious symbols in the public domain in India so far. So I don't think that should be the manner in which this particular issue is escalated, because then it takes away the attention from the central issues and perhaps possible reasonable answers and meeting grounds. So with that clarification, let me now proceed to what I agree with and what I disagree with as far as what the previous panelists have said. I'm completely in favor of what Professor Mustafa has just submitted, to the extent of saying that the very same argument that we made in the Sabarimala case, for which there were a lot of reactions that came our way, to the extent of saying that this is perhaps a regressive position, when we specifically said that secular constitutional courts are fundamentally incapable of performing ecclesiastical functions. And they do not have the training for it. This is something that we've been saying at least since 2017. And finally, because of the hijab judgment, so to speak, we have people making a similar observation. I wish that a similar observation had come about when the Sabarimala judgment came about, because our entire point was that there is a possibility that certain judges, thanks to their own erudition or their own interest or inclination, may be qualified to speak on a certain subject as far as religion is concerned. But as an institution, Indian judiciary is a secular institution and therefore lacks let's say, religious training. And therefore, I'm not going to be swayed by any particular individual's ability to comment on religion. I would rather ask two things. One, is the institution intended for this particular purpose? And second, does the institution have the training to undertake this particular exercise? It is my belief that the application of the essential religious practices test is completely flawed in these contexts, and I would even say it is impermissible. That is my position. In fact, since this issue is pending before the Supreme Court in the Sabarimala matter, ideally, I would have expected the Karnataka High Court to refer this issue to the Supreme Court, given the pendency of such a larger question before the Supreme Court. We have to understand that the ERP test, as it is popularly known, has been around since 1954, thanks to the Shirurma judgment. And a doctrine that's been around since 1954 stands referred to a larger bench in 2019. Therefore, if the Supreme Court itself has certain questions that need to be answered with respect to a doctrine that's been around for 5 decades at the very least, I would have expected the Constitutional Court of the state of Karnataka to follow suit. That's point number one. Point number two, what is it that could have been done in the facts of this case? First of all, I believe, without getting into whether this particular controversy has suddenly cropped up for extraneous reasons, I will strictly proceed to address this only on legal basis without getting into anything else. Firstly, I think the question is about whether there is any harm that is caused with respect to projection or, let's say, wearing of visible religious symbols in college campuses or in educational spaces. Because the first question is, you have to decide the space, whether it is a religious space or a secular space. And accordingly, you start asking the next question, which is, in a secular institution, what is the power of the government? And what is the countervailing right of the citizen, so to speak? I come from the school of thought which basically says that unless and until the wearing or the donning of a religious symbol is intrusive or is at loggerheads with a particular office, even if it happens to be a secular space, or particularly if it happens to be a public space, religious symbols must be permitted, is my position. For the simple reason that each time someone gives me the argument that but we are a secular country, secularism is the responsibility of the state. But as far as the society is concerned, it is not a secular society. It is a heavily religious society and a multi-religious society. Therefore, you must be able to strike a distinction between the infrastructure known as the state and the rest of the society. So the society has no responsibility to be secular, if I may put it so in those many words, because the society at the end of the day is comprised of both individuals and groups, both of which have their own religious identities. So in that particular regard, I certainly believe that firstly, in light of the pendency of the ERP tests and its validity before the Supreme Court, coupled with what I would call institutional inadequacy to look into aspects of religion and lack of training, perhaps this issue could have been addressed on different grounds. And two, as opposed to asking the question of whether this is essential, the question should have been whether there is, let's say, some kind of harm that is caused. Now, if the issue had been addressed from that perspective, I think the entire orientation would have been slightly more solution-oriented, which is to say, without compromising the very object of prescribing a uniform in a secular educational institution, how do we strike a balance between those legitimate considerations and perhaps even the legitimate rights of the students, so to speak, to wear and let's say have their own religious symbols displayed, so to speak? Is there a balance test that could have been achieved? Which means any visual symbol which is religious in nature, which has the effect of diluting or taking away the impact of a uniform, may not be permitted. But to the extent that there is no problem insofar as, let's say, the uniformity being preserved is concerned, such symbols can be allowed. That's been my consistent position. The only thing that I've had a serious problem with is the manner in which this particular issue has been elevated to project or to reinforce the stereotype of an Islamophobic India. I'm sorry to say that would perhaps be a serious mischaracterization, and it may end up contributing to problems as opposed to addressing problems. I do not believe that this was a case of any episodic discrimination against one particular community, because it's not as if every other community was being given a free pass with respect to the wearing of its religious symbols and only students of a particular community were barred from doing so. That is not what the facts of the case reveal. The simple argument was, if a rule applies across the board, can one particular community get a free pass? And therefore, to that extent, I think this was a fantastic opportunity to revisit the very purpose of the rule and the object it served. I think that would have been a better way to go about it, which is to say, what is the purpose behind this rule? What object does it serve? Does it let's say, subscribe to the doctrine of proportionality in terms of the object it seeks to achieve and the means, or let's say the actual restrictions it imposes on observance of a particular religion. These are, I think, the more specific and sharp questions that ought to have been addressed. Instead, I'm sorry to say, we perhaps went down the predictable path of asking whether this is essential to Islam. I strictly believe that if the essential religious practices test is applied in the manner in which it is applied in, let's say, in Christian contexts, it's going to be extremely difficult for non-scriptural faiths or non-scriptural traditions to pass muster. Because you have to understand that the essential religious practices test is the consequence of a Christian politico-theological framework on which I've dilated extensively in my book to basically say, if a faith system subscribes to the notion of a book and treats that particular book as being the fount of everything that you're supposed to do as far as that particular faith is concerned, and you choose to apply that yardstick of framework to other ontological systems and other theological systems, then you expect other faith systems to mirror themselves and mold themselves in the same framework as Christianity, which is extremely unfair. This leads to what I call judiciary-driven Abrahamization of non-Abrahamic faiths or non-book-related faiths. And as someone who is a practicing Hindu, I would be seriously disturbed when I'm asked to show the basis of a particular practice in a particular book. Because as far as Hinduism is concerned, it believes in customary law. It believes in evolution of practices. It believes in the context of sampradaya, which is to say, according to time, place, and location and whatnot, customs come about. And I should not be expected to prove the legitimacy or the validity of each of these customs on the basis of a particular book. Therefore, to say if it does not exist in a particular book, it is effectively invalid or it does not exist, would mean more than 60% of Hindu faith would be out of the window. Because most of these texts are not law texts, are not law books, so to speak. So I happen to have written on this particular subject to say that when the colonial establishment was trying to make sense of the faith systems prevalent in India, they started looking for equivalents of the law books of Christianity. And therefore, that particular framework was superimposed onto our books and our faith systems. And therefore, any book that happens to be a book that we refer to as a scripture was effectively treated as part of Hindu law or Hindu canonical law, which is not the way it is typically seen. For instance, the argument that Smriti is law is also incorrect because Smriti is merely descriptive in nature, or it is descriptive and prescriptive in certain senses, but it is not strictly prescriptive. Given these nuances, and given that this is itself a specialized area of research and study, so to speak, which I don't think, let's say, most lawyers are qualified to speak on, or for the matter, even judiciary as an institution is qualified to speak on this particular subject, there must be a certain degree of reticence, reluctance, and restraint when the judiciary chooses to go beyond the secular realm and chooses to apply secular logic to religious issues, notwithstanding the space in which it is applied. Whether it is a secular space or a non-secular space, if the right involved is religion or religious in nature, perhaps the judiciary must ask, if I'm happy to rely on handwriting experts to look at handwriting related issues, I'm happy to look at a scientific advisor, so to speak, on matters relating to science. Why is it that I choose not to fall back on the expert advice of people who are qualified to speak on this particular subject when it comes to theology? So one of the things that I've specifically said is that in matters relating to religion and where there is a confluence of religion and constitution before a court of constitutional significance, so to speak, there must be an institutionalized practice of appointing advisors coming from that particular tradition. And the voice of the person who qualifies as the expert from that particular tradition and his opinion must be given primacy, unless it effectively has the impact of going against public order, morality, and health, which is to say that to protect public order, morality, and health and other serious considerations in the interests of public, you already have filters, pass-through filters in the Constitution. When you have these clear filters, which save you the trouble of having to go down this rabbit's hole of asking something is essential or not, you simply ask yourself whether these filters are hit or are they triggered by the observance of a particular practice. And if the answer is a yes, then you're saved the trouble of rewriting let's say, the history of a particular religion. The most serious problem with secular courts performing ecclesiastical functions is that judiciary ends up rewriting the rules of a particular religion, which is seriously problematic for followers of that particular religion. How do we accept this from someone who's not even qualified to speak on that particular subject, who lacks the institutional training? And then, as the judgment, I think, in the Dargah committee case goes on to say, you can't reform a religion out of its identity and existence. And therefore, this never-ending tendency to reform a particular religion, I've clearly said, is the product of imposition of the Christian Reformation spirit on colonized societies, and that equally reflects in the approach of the judiciary to its own native systems. Because the judiciary still sees itself as the successor of the colonial establishment, therefore that reformist tendency and the reformatory tendency continues. I am not against reform. I'm only saying that you must leave certain aspects to the society to decide whether these practices are outdated or whatnot. Just as the individual has the choice to decide as to whether a certain practice they wish to subscribe to or not, I would extrapolate it to say even groups must be given the same kind of rights. But when those rights come into conflict with public order, health, and morality, the state has the power to step in. And with these safeguards in place, why do you wish to enter the realm of religion if you call yourself a secular entity? I think you're on mute, Dr. A.
Yes. Thank you, all of you. You seem to be in agreement on a couple of things. One, that the essentiality argument is one that should not be in the hands of courts, in the hands of the judiciary, and determination of what is essential to my religious faith or my religious practice and profession should be something that is perhaps an individual choice. But not something that should be second guessed by court. That's one thing. The other is that several of you said that the real issue here is a protest against the rule that the school has for a uniform dress in the context of the school. And that somehow the freedom of the young girls or people in general, but in this case, girls, to wear a headscarf that matches their uniform was either reasonable or unreasonable, but that the protest really had to do with that rule rather than with a wider issue. And there is certainly space for schools to require a certain kind of dress code, but it has to be fairly flexible in relation to the ability of a Muslim woman, girl to wear a headscarf, or of Sikh to carry a kirpan or wear a turban. These are all things that are in public spaces, a matter of without question. But you also say, and this interests me, that this whole question about religious essentiality is essentially before the Supreme Court. And I think it's right to say that there is a historical reason for the court somehow to have derived their way of thinking about things from scriptural traditions. I certainly would contest that in the Christian tradition, we do not have law books either, really, and the scripture itself is contested, as certainly there is, argument within Islam and within Judaism about what is the meaning of the text. So it's not something that should be handed over to a court of law. So there is I take it, a great deal of agreement among all of you, but there must be places where you yourselves have some question that you would like to pose to one another. And I think this might be a place to do that. And then we'll turn to some of the questions that have been asked from our larger audience. But do you have specific issues or questions you would like to pose to one another?
Yes, Diana, if I may.
Yes, Zakia.
So I have a counter to both Faizan, Mustafa, and Sai Deepak. I understand when they say that it should not be up to the courts to decide the essential religious practices. But then in that case, where is it going to be decided? On the streets? That is what has happened in the Karnataka situation. That is one. Second, when we are saying let the holy men or the religious men who are, or the ecclesiastical men who are in the position to decide, let them decide, that means we are relegating our women and girls to a whole system of patriarchy. Because we know that in our country and in several parts of the world, patriarchy masquerades as religion. And a lot of injustice to women and girls happens in the name of religion. And that's why, we have more faith in the courts than in our religious leaders. So it's very easy, to suggest that let the religious people decide, but I don't think it will be something acceptable to most women and girls, because it has, Sai Deepak also referred, and even Faizan, Mustafa referred, that unless there is a problem of public morality, health, and order, so injustice to women and girls is never considered, by and large, as a disruption of public morality and health and order. So it's a huge lacuna in the argument, because ideally, like I said, it should be for us individuals, for us men and women of the community, to sit across the table and sort it out amongst ourselves. And that's the spirit of the Indian civilization. And that's the spirit of the Indian society so far. And that's why we are a religious society, and yet we are a plural secular society. But that has been failing quite a lot of late. And the example of Karnataka is just, one major flashpoint. So, it all sounds very good in theory to argue the way they are arguing, but it takes a woman and her lived realities and the kind of injustices that she faces in our subcontinent at every step of her life, within the home and outside of the home, that, we cannot relegate such major decisions, such major life-saving decisions to the clergy. At least I am very clear about that. And I disagree with both of them on this.
May I just respond?
So we have a real issue here. We don't want to relegate it to the courts, nor do we want to relegate it to the spokespeople who tend to be the clergy. What kinds of commissions, what kinds of consultative bodies? I think you have suggested one, at least in the Sabarimala case. Sai?
So, Professor Mustafa, before you, can I just make one point?
Please go ahead.
Yes. I think there is a decent chance that Zakia ji has misunderstood at least my position. It is not my case that courts should completely stay off religion. That's not the point that was made. The point that was made is courts can arrive at a decision on some of these aspects on the basis of constitutional filters without having to decide whether a practice is essentially religious or not, which is to basically say, assume for a moment that you take the example of the triple talaq case. There are two ways of going about it. One is for the court to say, we believe that triple talaq on the face of it, whether or not it is sanctioned by the holy book of the particular community, violates certain principles of dignity and violates certain principles of public morality and constitutional morality. The moment the court takes that particular position, it is saved the trouble of having to decide whether triple talaq has any Quranic sanction. It doesn't have to go through Sahih al-Bukhari or anybody else's commentaries on this particular subject. So, ma'am, the point is not to say that please allow the men of a particular religion to have complete say and let the courts completely stay out of religious issues. That was not the point, ma'am. The point was on the manner of inquiry as opposed to the taking up of the issue. I'm not saying that courts must not take up such issues. I'm merely saying these inquiries, when performed by secular institutions which lack ecclesiastical training, must be secular in nature, which is to say, since you subscribe to secular rationality and secular logic, you use those, let's say, the very same filters and arrive at the very same conclusion. You don't need to go down the path of examining a religious book because you're not trained for it. So the outcomes in the hijab case, whether or not we like it, or the outcomes in the triple talaq case, whether or not we like it, or even in the Haji Ali Dargah case, could have been arrived at without the courts getting into the inquiry of whether something is essential to religion. That is the position, ma'am. That's point number one. Point number two, let me also say this. Let's take a look at a couple of examples. Assume for a moment, a woman in the Muslim community is forced by others, whether it's men or women, to undertake or perform a certain practice which the girl refuses to, citing patriarchy and her choice. In such a situation, it is always available for that particular individual to assert her individual rights, so to speak, and say, I do not wish to live by your principles. And for this to happen, the courts are always there to protect those rights. Courts can protect the rights of individuals when other members of the particular community choose to impose a certain expectation on an individual. To that extent, it's possible. 3, I'm also making the submission that I'm not asking you to put faith only in the men of a particular community, but the fact of the matter is people like you also exist, which means I'm putting faith in the ability of a community to produce voices such as yours, which are in a position to say, this is an alternative position, this is a dissenting position, we too have to be heard. But if this entire issue were to be relegated to courts, I'm sorry to say, scripture and tradition, which has evolved over centuries and millennia, so to speak, after a lot of thought and after a lot of training, we expect the court, which with its already clocked system and with its inability to completely wrap its head around religion and the nuance of every particular religion, to sit and decide over these issues. As a lawyer, I can't be an expert in tax law, intellectual property law, constitutional law, and everything under the sun. But I'm expected to be an expert in Hinduism, in Judaism, Sikhism, and all these matters will come before the court. That's the point. So the issue is, how do you resolve this particular controversy without rewriting the rules of religion? Because rewriting the rules of religion must be left to the community, not just to the men of the community, but to churn within the community so that all stakeholders can decide whether this is the way forward. So I am not a status quoist in this particular regard at all. Please note that. That's my position.
Thank you. And I think from what I've read of Zakia Soman as well, the issue of reform is an important issue in every religious tradition, because religious communities and their traditions are dynamic. They're not fixed in the past. And yet whose voices come into the reform of particular understandings of religion? Professor Mustafa, I think you wanted to come in on this question as well.
Right. Thank you, Professor Diana. I was expecting that Zakia would be uncomfortable with my and Sai's stand, because her concern of reforms is a genuine concern and it is to be addressed. But just like Sai rightly said, this is not our position that we leave religion entirely to the clergy. We are on how courts should look at religion. So now, for instance, I, in the very beginning of my presentation, said that freedom of religion has been subordinated under Indian Constitution to other fundamental rights. So if there is a conflict between right to equality and right to non-discrimination and your freedom of religion, you don't have freedom of religion. If you don't have freedom of religion, why should you go into whether it is an essential aspect of your religion or it is not an essential aspect? Because even if it is an essential aspect of your religion, still you are not entitled to it. So the courts, in giving their judgments, should stay within the common law. Just to give you an example from infamous Shahabano case. Now in Shahabano, what was the matter? Here was a divorcee who had gone to the court against her husband, who is refusing to pay maintenance after divorce, because his claim is that my liability to pay maintenance ended once the iddat period of 3 months and 10 days have ended. So there was a provision in our Code of Criminal Procedure 125, which makes this as a responsibility of the husband to pay maintenance. Then there is a provision in section 127, which says that if you have made an amount due under customary law on divorce, then your liability to pay maintenance comes to an end once the relationship ends. Now, what the court said it, in fact, they said it that, well, whatever meher you pay, dower, on divorce, that is not an amount due under customary law on divorce, because meher or dower under Islamic law is payable on marriage. It has nothing to do with divorce. And therefore, the court could have easily said that the benefit of section 127 is not applicable in this case and you are liable to pay maintenance. They should have stopped here. Now, what the court did, instead of stopping there, it went to Quran and quoted verse number 241 and said, well, this is there in Quran also, that you should pay maintenance to the divorcee and it is a duty on the righteous. Now, Muslim fanatics hijack the debates. The ulama hijack the debate. The clergy hijack the debate, and you will be surprised, Professor Diana, many of them said, well, we are not the righteous. Many of them were to such an extent. So I am saying that we should not, a secular court in giving judgments should not seek justifications in the scriptures. That is not their burden. They should ensure gender justice within law. If there is any provision in any religion which is unjust to our women, whether it is essential or it is not essential, it should not be permitted without any inquiry into the religious scripture. This is my position, and I think this is a position which is similar to Sai, and which Zakia is probably not understanding. Two, when you look at the whole hijab controversy, there are words used in Article 25, subject to public order, morality, health, and other provisions of this part. Therefore, anyone who is trying to curtail religious freedom has to say whether these three restrictions are in play. If they are not in play, then you have to concede freedom of religion. The danger of courts taking over the role of reforming religion is to fall in the trap of religious fanatics. And that I think we should not do. But absolutely there has to be a zero tolerance when it comes to unjust practices in religions. And as I gave you example of slavery in Islam, I gave you example of triple divorce, assuming for the sake of argument that it is in Quran, assuming for the sake of argument, it is the most essential practice of Islam, is still a modern secular court should refuse to uphold it because we cannot be permitting it. We are saying this is our modern legal system, X, Y, Z, we will permit, A, B, C, D, we will not permit. Because this whole interest of the court going into religious questions unnecessarily complicates the debate. Because in the religions, as you rightly said, Professor Diana, that there is no agreement on anything. So if there can be, 10 arguments to say that hijab is not there in Quran, there will be other scholars who will come up with other verses and will say, well, it is there in the mandate. So a court should not go into that debate. A court should decide cases on the basis of Indian Constitution and modern Indian laws without going into the religious scriptures. This is the limited point we are taking, but we are definitely not going to leave our women or women of any other religion at the mercy of the clergy. I entirely agree with Zakia, that will be far more dangerous. Our courts, if you have to make a choice of evil, are definitely much lesser evil because at least they are impartial, at least they are wedded to the constitutional vision. But we are not on that right now. We are looking at the whole question. For instance, the question was whether the untouchables can be allowed in temples. Now, the answer of the court should have been untouchability has been abolished by Article 17 of the Constitution, and all untouchables are welcome. What the court rather did, it quoted scriptures to say untouchability is not an essential feature of Hindu religion, which can be debated. There can be, scholars who will say, no, untouchability is very much central to Hinduism. So I think courts should not, exceed their brief. They should stay within the four walls of modern legal rules.
I think let me just be sure there. My sense is that all of you are agreed that this question of essential religious practices should not be something that the courts involve themselves in. Let's just get rid of it. Don't have essential religious practices as something courts should involve themselves in. But we come to the distinction that I think Sai made, and that most of you would agree, that secularism, however we understand it, but as the equidistance of the state from religion, there is no state religion, etc. That's a constitutional matter. But then what about our society? Because in India, there is a multi-religious society. And the multi-religious society is not necessarily secular. There are lots of different competing interests and groups, and they sometimes organize themselves politically. Politics is not constitutional law either, really. So if we look at this in a societal way, we have that further question of what is the future of religious pluralism in India. And I'd like to just touch on that because in a way that's the larger and more important question here. How, as a society, are we going to relate to one another? Are we going to argue with one another? Are we even within our own religious communities? So what do you see as the future of religious pluralism and of a multi-religious society in India today? And obviously, it's not only India's question. This is the world's question in some ways. Who would like to start off on that? Zakia, you've written on this, the future of multi-religious harmony. Do we have a chance?
Yes, definitely. I'm optimistic. Although right now, we are at a point in history where a lot of competitive religiosities and a lot of hate speeches has become the norm. But still, I would like to think that it is an aberration and it's not the rule. I still feel that there are any number of Indians. In fact, there are majority of Indians who are very religious themselves in their personal lives, but have a faith in, coexisting with people from other religions and other kind of cultures and practices. And that has been the hope, Diana. And also, there are any number of, there is evidence, there are any number of examples that even when there is a highly politically charged, religiously charged incidents happening, there are always Indians who stand up for brotherhood and for peace and for harmony. The latest example was, the Jahangir Puri incident in Delhi. There was a Ram Navami Yatra, and there was a violence, and there was both the communities, Hindu-Muslim violence took place. But equally, the residents of that entire locality, comprising Hindus and Muslims and Christians, took out a Harmony Yatra, an Aman Yatra, where they participated in large numbers. And they all came with their religious, respective religious clothings and symbols and all. Some of them were in skull caps, some of them were wearing saffron scarves and all. And they all hugged each other and they all sort of feted each other and, presented refreshments to each other, women and men and children, everybody. So I think that spirit of pluralism, which has been, embedded in our society, I think that is the hope, and this too shall pass. And I am not. I belong to Gujarat, and I'm used to. Like my entire lifetime, has been virtually between one communal riot to another. Beginning right at the time of my birth in the 60s, and there was a major riot in 1969 in my city. And in my family, for 4 generations, we are survivors of communal riots, and we have seen it all. And yet, I feel hopeful, and my hope is the ordinary Indian woman and man, who can be extremely religious, but still is quite fine, is quite okay, with the religiosity of other people who come from their other faith background, and they coexist. So although there is a heightened politics of religious division and hatred, but I think that's an aberration, and that too shall pass.
Sai, let me turn to you and say, with that question, do you have a vibrant hope for societal coexistence among the communities of multi-religious India?
So I think given India's history, I think India itself is the survivor of a massive riot, namely the partition. Okay. So given that history and in the backdrop of that kind of a bloody origin for our so-called modern existence, I don't think we should play down the existence of real problems. The question is, how do you wish to resolve these problems? Do you wish to go back to the old school and draw the sword? Or do you choose to treat the Constitution as a facilitator of dialogue? And hopefully, even if it doesn't lead to resolution, at the very least, does it lead to what I would call providing a safety valve for anger? Okay, because I'm never going to subscribe to the school of thought that the Constitution will resolve all issues which have, let's say, origins which antedate the Constitution by several generations. I don't believe that. I don't put that kind of faith in the Constitution. However, I certainly believe that we are at a certain crossroads, and I hope that this yields greater discussions. And hopefully, the basis of the discussion will not be mushy sentiment, but facts and evidence. Since every discussion that is based on sentiment is premised on a certain predetermined goal, which is to say, I have a certain goal to reach, and therefore I will tailor the discussion according to that. That I think would be a fairly problematic issue. I would rather base any discussion on truth and facts. So I hope we have more fact-based discussions, but just give me about 2 minutes, just 2 minutes to make one point, because you opened this particular round of questions with the essential religious practice. So let me just give the participants a brief background so that we have a clearer picture of what is the problem with this practice. The Constitution has two provisions, 25.1 and 25.2, and I'm sure Mr. Mustafa or Dr. Mustafa will agree with me by the time I'm done with this. 25.1 and 25.2 are two limbs of the same provision which deal with individual religious freedoms, Article 25. Now, 25.1 speaks of the right to practice, profess your conscience and freedom, so on and so forth. 25.2 has one limb which effectively says that the state shall have the right to pass laws with respect to regulation of activity which is secular in nature and which is not religious in nature. That is the broad nature of, that is the broad phraseology. The essential religious practice doctrine was formulated in the context of 25.2, which is to say, between a secular activity of a religious institution and a religious activity of a secular institution, how does one draw the line? So that the state has power only over secular aspects of a religious institution and not the religious affairs of that institution. So the essential religious practices doctrine was distilled and was carved out to strike a distinction between these two aspects. Post 1954, the doctrine has been consecutively, successfully, or rather successively, but unfortunately applied in the context of determining what is an essential religious practice under 25.1, which is to say, the doctrine has its origins in a very different realm altogether with respect to a very different context altogether. So assume for a moment, just for the sake of humor, there exists a church of Professor Diana Eck. Okay. And Professor Eck chooses to start her own Christian denomination. Let's assume that is the case. And then this church goes on to collect contributions from people to say that I wish to buy certain land for this church. I wish to have certain property and endowments for this particular church. Now, in the process of doing so, if there is a scope for misfeasance or malfeasance or mismanagement of the funds that are sought from the public, those are the kind of activities which the state can get into. To say that you have used religion, but in the process you have initiated a secular activity which is to collect funds, and you're diverting it in a slightly different direction, which cannot be permitted. So in such a situation, 25.2 steps into the picture to say, the law shall come out with, or the state shall come out with legislation that governs the conduct of this secular activity, which is collection of money. Or for that matter, if Professor Eck were to be seen as delivering political speeches or rabid speeches from her church, then the state has the right to say, I wish to see what is going on inside this particular institution, because this is not purely religious, this is also political in nature. In stark contrast, under 25.1, it's a plain and simple question of religious rights. the essential religious doctrine was formulated in the context of separating secular activity from religious activity in the context of religious institutions. But over the decades, it has now been applied to see what is that particular practice of a religious, of a faith, so to speak, or a religion, so to speak, which is essential. Therefore, the sum and substance of my point is the very object of formulating this doctrine is not the context in which it is being applied today, and that is not the context in which it was formulated in the first place.
Thank you. That's a very important clarification. Thank you for that. I'm going to give Professor Mustafa a chance to talk about, well, I mean, let's take the overarching issue of the future of religious pluralism in what is most definitely a multi-religious society.
Thank you, Professor Diana. I again agree entirely with Sai, and I would also say that it is not just 25(2), which is a context. 26 is also there, where in matters of religion, we are giving freedom, and this freedom under 26 is wider than the 25 freedom because it is not subject to other fundamental rights. But answering your question, Professor Diana, I am little worried. I'm not an eternal optimist like Zakia because I see excessive rise in religiosity. And this rise in religiosity is completely devoid of spirituality. This rise in religiosity has elements of hate, enmity, elements of superiority and inferiority, inclusion and exclusion. It is going against the constitutional doctrine of fraternity, because in our preamble we not only talk of liberty and equality or justice for all, we are also talking of fraternity. I always believe that we have wasted last 70 years in a debate about secularism, which is largely about state's relation with religion, that the state has to be religion neutral and has to keep equidistance from all religions. But this whole concept of fraternity and brotherhood and sisterhood and how should we improve relations between faiths have not been given the prominence and the due importance. I also feel that freedom of religion also includes freedom from religion, and it also includes freedom within religion. On both counts, our record is pathetic. We have not given freedom from religion to people who want to go out of religions. Similarly, we have been very, very harsh on minorities within religions, minorities within minorities, and the whole question of rights of women in Islam, for instance, comes to my mind. But having said that, I just like Zakia would say that if at all we are secular, or if at all we are tolerant, and if at all we have a better intercommunity relations, it is entirely and largely because of the Hindu community. Because post-partition, when the partition part became a theocracy, it was well within the power of Indian Constituent Assembly to declare India to be a Hindu Raj. And they took a call and said that we want to be a secular state. And look at any communal right, and look at any minority issue, the more vocal voices for the minorities will not be the minority voices. These will be the voices of fellow countrymen. These will be the voices of Hindus. If you look at newspaper editorials, which will be written on all such communal incidents or hijab controversy or this and that, these are all writers are Hindus. So I have great faith in the majority community and great faith in our constitutional scheme. I don't see that we are truly going in a wrong direction. The situation may not be very conducive. We cannot anymore say that these are fringe, the fringe mainstream, and it should be a cause of the concern for the majority community. because our score on civil liberties, be it the Freedom House ranking or VDEM ranking or Amnesty International rankings, is not very encouraging. On rule of law, we are not doing very well. And if we do not have peace in our society and we keep on having such controversies, the foreign investors will withdraw from India. There is already withdrawal of some 20-25% of wealth in last few months. And I also see that India's claim as the Vishguru or as the moral leader of the world, which unfortunately America has lost in last few years, we could have filled that space, it gets undermined. So it would be good for our country, the country of our size, with all kinds of diversities, that we have peace and we sort out these questions. I'm really worried that systematically we have created a kind of fear in the majority. Ki Hindu khatre mein. I think in any democratic country with massive majority of about 80% or so, that kind of fear should not be created. There is no threat to them. And similarly, the Constitution fully protects the rights of the minorities as well. Muslims in India have far greater religious freedom than Muslims living in many Muslim countries. And we should be able to solve these problems. But the only way is, as Zakia rightly said, is through dialogue. And Sai also said, through conversations. We have misgivings and several myths about different religions, and talking can really help.
Thank you very much. And I think we're approaching our time frame here. So let me say a brief word in conclusion, which is to Sai's point, some of these issues long predate the creation of the modern Indian state. The issues of processions going out, playing music in front of the mosques in a noisy way, or of processions going out in Muslim areas or Hindu areas with the questions of halal sacrifice, etc. I mean, these are old issues that have had symbolic PowerPoints and flashpoints. But I think the question of whether we choose to look at and amplify the voices of dialogue and the voices of intercommunal harmony, or whether we persistently weaponize, that was someone's word, the particular voice of our own community, is really an important one. And I think the test of a secular society is to be able to speak up for one another, that the rights of one and the issues that an individual community faces should be the concern, not simply of the people of that community, but of everyone, of the whole citizenry. And it's important not to lose that. In the United States, we certainly have some of these same issues. I decided to look at what I think of as the building blocks of pluralism in America. At the same time, there were other scholars who were diving into all the issues of fundamentalism, not only in the United States, but around the world. But I thought it was more important for the future to look at where it actually is working. Where are people reaching out to one another, listening to each other, engaged in that respectful dialogue with each other that is going to be so much the fabric of a multi-religious society. And as you know, America has become much more multi-religious in the last 70 years with immigration from India, among other places. And the fact that the religious communities that I may first have known in Benares, whether Hindu or Jain or Muslim, now are part of the fabric of the United States, is not a a small matter, that we are multi-religious in ways that people have never really recognized before. So what are the places that the interfaith infrastructure is being created in the United States? Not just the infrastructure of trains and roads, but the infrastructure of people who are reaching out across the various communities to try to find common cause. And there are lots of common causes to have these days. When I look at this issue in India, I think of the massive number of NGOs in India that deal with everything from women's issues to issues of poverty, to issues of employment, to issues of local governance, to issues of the environment. And those are many of the places where people come together across communities. And the same is true in the US, where we have absolutely hundreds of interfaith councils, interfaith initiatives, interfaith organizations, and interfaith action, really, that is vital to the future of our democracy in the US. And at the same time, we do have majoritarian voices that are essentially new forms of white Christian nationalism in America that need to be resisted. So this conversation has been important to me as someone who's trying to learn about the ways in which India has been and will continue to be a multi-religious democracy. And where are the threats to that? And where is the politicization and weaponization of our religious communities? Those are things that we need to be very alert to in other democracies. We can look to India and say, where is India now that we need her so much in the world scene? The United States needs to ask the same thing about ourselves. Where are we now that the chips are down on whether a multi-religious pluralist democracy can work? I think all of you have contributed in a very important way to this discussion today. And we have in the chat questions that have been addressed to each of you and to all of us as a whole. But the way our discussion sort of moved along, I think it was very fruitful to have you respond to one another, because I have felt it a great privilege to be on the same frame with your voices in discussing this important topic. Thank you so very much. And Hitesh, I turn it now back to you. You're muted, Hitesh.
I'm sorry. I said, thank you very much. And it occurs to me that you're the best possible guide on this discussion of how to create pluralistic, multi-religious societies, having studied both those deeply in the US, as I said at the beginning, and in India. Thank you very much, Professor Eck. I want to thank all three of our panelists for your very thoughtful, subtle comments. I want to go back to what I said at the beginning, which is there's always a privilege to being somehow connected with debate in India. We are a society that has thrived on debate and concourse, samvad and vivad from the most ancient times. And, here we see today the fruits of that thousands of years later. Your conversations, besides being rich, also opened up entirely new avenues that we should all be exploring together. What is the nature of a secular state? Sai, you also brought up a very interesting point. In a multi-religious society like Indian society, when you have different religious streams, the Ahle Kitab ones, and then the Hindu, Buddhist, Jain, how do courts even decide what the frames are in which to look at these questions? And can they be the same? Must they be different? And if they're different, do we move away from secularism? There's so many beautiful avenues of thought to explore. I hope we have more of a chance to do that. Thank you again, all of you. Thank you to all of the people who are listening. I'm sorry, as Professor Eck said, there was such a rich discussion. She was right to have the panelists speak with each other. It was really a wonderful samvad that we were having. We look forward to seeing you all again for more. I want to thank also our team for doing such a good job in putting this together. Namita, especially thank you to you and Neha. And with that, a good day to everyone, wherever you are in the world. We know people are joining from all over the world. Please come to more Mittal Institute events and check us out on the web to see what we're all about. Thank you so much.